Great. Good morning, everybody. My name is Marty Mascari. I am a contractor with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We are blessed once again to have our friends at Heyman Hogue here this morning to talk to us about guardianship, what you need to know. But before we get started, I'm going to advance a slide and we'll get Sheila to go over the CEUs and CEU requirements. It's all yours, Sheila.
Good morning. Well, as you know, at Heyman Hogue, we're always happy to give these CEUs because an educated public is better for all of us. Not only for your personal edification, but for those that you help as professionals, because there's a lot of professionals on here every time. And that way, your patients, clients, whatever, or family, then you can be educated better to help them. This is a touchy subject this morning, and it's actually the saddest thing that we do. So there's a lot to it. Here's two things that you need to get your CEUs, and I'm talking about for social workers, counselors of any sort, and case managers and assisted living managers, which I wish would join us. Very rarely do they, and attorneys, because we give CLE credit as well. So any of you, what I need is two things from you. You will get this from Marty, an eval form, which you're used to filling out every time you attend a CEU, and a sign-in sheet. So both of those need to be returned to me, Sheila at Heyman Hogue, and then I'm happy to send you your certificate.
Great. In addition to that, and we surely appreciate you offering those CEUs because you're set up to offer more than we are. But please note that we've given you a week, a little over a week to get those back to Sheila. And we're starting to cut that date off just because it is incredibly time consuming to get emails one at a time and to have to do those. Once we get them out, we've got to move on to the next training and the next CEUs we're working on. And I've told people before, I've chose to do more webinars and help more people than to be letting my time get bogged down on chasing down one CEU here and one CEU there. So please make sure you meet that deadline. In addition to that, we have a Google survey that we're asking you to complete. That should pop up or give you the option to go to it as you log out of Zoom today. But if not, you'll also receive that in the follow-up email along with the attachments that will be Sheila's two documents that will go out sometime tomorrow. That being said, Sheila, I'm going to let you introduce Fred and we'll get rolling.
Well, once again, you have the founding partner of Heyman Hogue, Fred Heyman, who has more than 25 years of experience as a lawyer, but he also has, and it's invaluable in this situation particularly, he has 5 years of experience as a police officer. So actually, it certainly builds on that for him to do guardianship, because like I told you, guardianship is one of those situations that's very sad, and he's going to go into all the details, but is also unfortunately very necessary, and it's happening more and more in our society today. Fred is very knowledgeable and will be happy to answer all of your questions at the end. So please hold those. You can put those in the chat, and I monitor the chat. And at the end, we'll give you a chance to have Fred address those questions. Okay? Without any further ado, Fred.
Thank you, Sheila. I appreciate it. Thank you, Marty. It's good to be here today. We are going to talk today. Go ahead and move forward the slide, Marty. We're going to be talking today about guardianship. And for those of you all that are not real familiar with this area of law, or some people think they are, but it's really kind of confusing, is different states call it different things. And so if you're not from Texas, you may be familiar with a term called conservatorship. And in Texas, we call it guardianship. In Texas, conservatorship is when children need to be taken care of. And for instance, if I needed to take care of my 5 and 6-year-old niece and nephew, because my sister is not able to care for her own kids, then I would go to family court and I would get a conservatorship for those children so that I could be their step-in parent. In Texas, a guardianship deals with people that are adults that are incapacitated that can't care for themselves. So this is a rather confusing subject, because if you're from another state, or if you're watching this from another state, they flip-flop those terms. And so some states call what we're going to talk about today conservatorship instead of guardianship, and call guardianship going to family court for children. So I just want to make sure that we're all kind of on the same page. Guardianship in Texas is really two areas, and we'll go into it in detail, but there's guardian of the person and there's guardian of the estate. And 90% of the time, it deals with adults, anybody over the age of 18 who has, for some reason, a mental or physical incapacity, and they are unable to care for themselves, and therefore they need somebody to be appointed their legal guardian. The only time I do guardianships for children is when a child inherits money. If a child, for some reason, comes about some money and somebody needs to manage that money for them, even a biological parent, that parent or step-in might have to become guardian of the estate to manage their money. So we'll go into that in great detail, but just so everybody's on the same page, 90% of the time we're dealing with adults in these situations. Next slide. So guardianship is, go ahead and move forward. I think some of these require a couple clicks, Marty. Guardianship is a court-supervised administration which appoints a responsible person to take care of an incapacitated person. And as you can see by this definition, it says take care of a minor or an incapacitated person. But as I said earlier, if you're going to, there's not a guardianship of the person for children. So if I need to become a parent figure for a child, that's when I go to court in family court and I become a conservator of that child. If I need to manage that child's money because they inherited it, then I would go to probate court and become guardian of the estate for that child. But for people that are over the age of 18, guardian of the person and guardian of the estate take place both in probate court. Next slide. So guardianship is a relationship. It's a court order relationship where we take the person that needs help is termed the ward. The ward, you've probably heard the term the ward of the state, but this is a ward in a guardianship. A ward is a person that needs to be cared for, and the guardian is the person that will be caring for them. Next slide. And again, as I said earlier, it's a process that involves adults much more than it does children. So guardianship for a minor. Now, I've had some cases over the years involving minor guardianships, and they again always involve money. Why would a child have money? A child comes about money because a person dies and leaves them money. That's the typical situation. I had a big case in El Paso years ago when I was practicing law in El Paso. Unfortunately, I was practicing law in El Paso when the cartel killings started and got really, really out of hand. And I think in 1 year, I want to say 2010, 2011, 2012, somewhere around there were over 3,000 people murdered in Juarez across the border from El Paso. Those some of those crossed the border because the people that were killed were American citizens who lived in El Paso. I had a situation where a young lady was murdered. She had 2 young children. Can't remember, but they were both under the age of 10. She had left $1 million life insurance policy to their benefit. The mom and the dad were divorced, but dad was involved in the children's lives. So the mom and dad were both involved in the children's lives, but because mom left money to the children, biological dad, even though he automatically became their conservatorship because he was going to raise them and that nobody was questioning that, he had to go to probate court. We had to file guardianship of the estate so that he could get the right to manage that money for the children. Now that money was put into a special accounts. It was set aside specifically. There was a lot to it. And unfortunately, it's a very expensive process to go through those type of things. But that's when you'll typically see situations involving guardianship of minors. Next slide. So let's look at some of the terminologies that deal with guardianship. There is a certified guardian. The state of Texas will certify somebody to be a guardian. Now, if you're not a certified guardian and you want to become somebody's guardian, you'll have to go through a certification course. Every person that wants to become a guardian has to take this course. Now, I'll be honest, I've not kept up with it. I'm not sure. I think it's a 3-hour course. I think you can take it online. I'm not sure all the details because it's been a while since I've dealt directly with that. But yesterday, I noticed that somebody that logged in this morning said they were from Cleburne, and I hope I said that right because I never know how to pronounce these names around here. I remember the first time I went to what I thought was Gunter, and it's Gunner. So Cleburne, I was out in Cleburne actually yesterday for a hearing, and it was a child who had autism, who had turned 18 and now needed a guardian for that child because he could not care for himself. And great aunt and great uncle were stepping in to take care of them. Great aunt and great uncle were the only, it sounded like, responsible people in that immediate family. But they were willing to step up to the plate. And part of what they had to do, and we had to submit to the court yesterday, was their certification that they went through the course required by the state to become a certified guardian. Next slide. There are corporate fiduciaries that come into play. Most of y'all have heard the term corporate fiduciary. It is a institution of some kind, usually a financial institution, that takes care of money. So in some of these cases, we have to appoint a corporate fiduciary. In my opinion, I try to avoid that. With my clients, I try to avoid that because there are difficulties when you deal with financial institutions that you don't have when you're dealing with individuals. There are costs involved with dealing with them that usually you don't have with individuals. But sometimes when there's a lot of money or when there's issues involving money or there's fighting within the family and no people can't agree to things, then we have to appoint a trust company or a court-ordered guardian, receiver, trustee, executor, or administrator. Those all come into play sometimes when we have money that there is a concern about it being properly managed. Next slide. There are certain companies that engage in the business of providing guardianship services. I have found it extremely difficult in the Dallas-Fort Worth area to find companies that do this, that they do this for a living. They're professionals in this area, and this is what they provide. Surprisingly, when I practiced law in El Paso, it was a lot easier. We had Project LULAC out there and some other agencies that provided professional guardianship services. And where these really come into play is when you have a person that needs a guardian but doesn't have a family member or somebody that can take care of them. I've had to deal with this in situations where we've had homeless people that had serious mental disorders that needed care and they needed somebody appointed, but there was nobody there. We couldn't find family members. We couldn't find anybody that either could do it or that was willing to do it. And so we have to find professional guardianship services. If anybody is out there looking for a business to get into, I would look at this one because I tell you, as an elder law attorney, as an attorney who does guardianships, and I can probably speak for most of the attorneys that are in my arena, we need people. We have this come up all the time, and we have trouble finding people that are in the professional business of providing guardianship services. Now, the one I dealt with, I dealt with some private professionals in El Paso. And the neat thing is, one of the ones I dealt with, they had individuals within the agency that focused on being a guardian of the person. They were the caretakers. They were the ones that would make sure that the person lived properly, got their medicine, went to the hospital, doctors. They did all the care part. And then they had other people in their organization that were professionals with the money. And they managed the guardian of the estate. They managed the assets and the spending, and where you have to track all the money that goes in and out and all that kind of stuff. So this is a very needed service. When you're the person appointed as the guardian, there's different categories, I guess you would call them, of guardian. There is the initial guardian that is appointed. There are successor guardians, and they're temporary guardians. When you appoint a guardian in Texas, I don't know about other states, but in Texas doesn't allow us to appoint a guardian and a successor guardian at the same time, which I don't like. I don't like that part of our process. I wish they would change that. But if I appoint somebody as guardian and they can't do the duties, let's say they've been guardian for a while, their health is declining, they can't care for them, their loved one like they used to, and they need to step down, that requires us to go back to court and get a successor guardian appointed. Now, to me, it would be much easier if we could do it at one time and have a successor guardian in the bullpen waiting to step in when we needed it. But unfortunately, the courts don't allow that to happen. But it's not a bad idea to have that in mind of who would be that. I was on the phone yesterday with a couple that's in their 60s. One of the couple got severe Alzheimer's, needs care. The other party, the other spouse, wants to be guardian, but at the same time says, I'm aging, and I'm afraid I don't know how long I could do it. And one of the children is ready to step up. And so our decision when we apply is going to be, okay, who is going to be the initial guardian? Because we can't name a successor guardian. We'll have a successor guardian ready if we have to go back. But if we do, we'll have to pay more money. We'll have to pay more legal fees. We'll have to pay more court costs to get the successor guardian put in place. A temporary guardian is a different animal. And temporary guardians, we find, only happen in emergency situations. The courts do not like appointing temporary guardians unless there's an absolute emergency, an emergency to the person's health or emergency to their person's finances. If they are being exploited and taken advantage of, or if there's a serious concern that they're going to harm themselves or others, then the court will step in and let us do a temporary guardian. And typically those temporary guardians convert to permanent guardians within a few weeks after we get them in place. Again, as I mentioned earlier, the guardians fall into two categories: guardian of the estate and guardian of the person. Just to reiterate, the guardian of the estate is like Bank of America. They're the fiduciary responsible for the money. And the guardian of the person is like the caretaker. They're responsible for making sure the person is properly cared for. Next slide. So there are guardianship programs and guardianship services. I'm not going to go into great detail in these things because they're a few and far between, especially in the state of Texas. We're hurting in these areas of companies and people that provide this service. But the Texas Estates Code, which governs the laws dealing with guardianship, they outline some areas where there can be some programs and there can be some services provided. Again, the definition of programs does not apply to service providers that provide guardianship services pursuant to the Health and Human Services Office. So the state, the government itself, is not under this category of guardianship programs. But again, I think in these two areas, if you're looking for something to open a business and this is a passion that you would have, I would look at these areas. Next slide. So as I said earlier, the Texas Estates Code is what governs the laws dealing with guardianship. The Texas Estates Code is the law of probate court. The Texas Family Code is the law of family court. And family court is completely different than probate court. And the law has become so specialized over the years that typically attorneys that work in one area, they don't work in the other area. Or if they do, they're not very good in either area. It's kind of like a doctor that is a general practitioner. There are general practice doctors that you see typically first. And those doctors, the smart ones, know their limitations, and they know a little bit about a lot, but they don't know a lot about a little. And so when they have an issue come up that's dealing with your heart, they're going to send you to somebody that specializes in the heart. When they have an issue dealing with your colorectal or your intestinal issues, they're going to send you to a colorectal specialist. Same thing with the law. The law falls into such specific categories that when people come to me and they say, well, I've been told that I need to become conservator of my minor nephew, but I also need to be guardian because he has money. Well, I tell them, I'll do the guardianship, but we need to get you a family law attorney to do the conservatorship because I can't do both. I don't know what goes on in family court because I'm not an expert of the family code and the laws dealing with that. So the Texas Estates Code governs this area. Texas Estates Code 1002.017 defines the term incapacitated. The unique part of this definition, I find, is number one, incapacitated person is a minor. So until a person turns 18 years of age, they are considered incapacitated. That's kind of an insult to some kids, but that's why children can't enter contracts. Children can't marry on their own without permission. Children can't consent to sex without at all until they're 18, because until they're 18, they are considered incapacitated. An adult also becomes incapacitated if their physical or mental condition enables them to feed themselves, clothe themselves, shelter themselves, care for themselves or their physical health, manage their own financial affairs. Or a person who must have a guardian appointed to that person to receive funds due to the person from a governmental source. Now, number three, even though it's part of the definition, typically we can get around that a lot because a lot of the governmental agencies don't require guardianship in order to have a person responsible for receiving governmental funds. For instance, Social Security, I can become a designated payee for my mom. My mom is 91 years old, and I am her designated payee for her Social Security. The Social Security Administration allows me to become the responsible party to accept money on behalf of my mom and to pay her bills and take care of her without having to go to the extreme expense of becoming my mom's legal guardian. So if you have a situation where there are governmental benefits or governmental funds, talk to somebody, consult with an attorney before you just jump into, we don't have a choice, we got to become guardian. Next slide. As I said earlier, the ward is the definition used in the Estates Code for a person that needs a guardian appointed. The ward is the person that's incapacitated by means of either physical or mental condition. Next slide. There is a code of ethics for minimum standards for guardianship services that needs to be abided by under Section 155 of the Government Code. That's what makes the law so darn complicated, is that there's so many areas that cross over from one code to the other code, and that's how ridiculous our lawmakers are, because they can't put it all in one place. For instance, one of the things I deal a lot with in my probate area when I'm probating cases when people pass away, although all probate laws fall under the Estates Code, if I have property involved in my property, my probate, I have to look at the property code and see what the property code says about how that's supposed to be dealt with and all. So this is the same kind of thing. Even though guardianship laws fall under the estates code, the code of ethics and minimum standards fall under the government code. There are private professional guardians, as I mentioned earlier. These are persons, attorneys, corporations, corporate fiduciaries, people that are licensed to provide guardianship services. And they're provisionally certified guardianship. These provisional are temporary. They can be their services from the state and from the commission, where a person can temporarily step in to provide these services until we can get somebody permanently appointed. Next slide. This slide I'm going to kind of just skim over. You guys can read it. You're going to get copies of all these slides, but these are really just dealing with the commission, the Texas Commission on Health and Human Services, their supervisor definition or their volunteer definition of where you fall into providing these kind of services. Next slide. Types of guardianship. Let's go into the specific types of guardianship in more detail. Now, if there is somebody on our presentation right now that I think Sheila said that there were some people chiming in from El Paso. I am a former El Pasoan. I grew up in El Paso, and I was a police officer in El Paso for 5+ years before starting or as my chief of police at the time said, before I went to the dark side and went to law school. And then I practiced law in El Paso until 2013, and then moved my family out to the Dallas-Fort Worth area. But those of you all from El Paso or have been to El Paso might recognize the picture on this screen as Mount Cristo Rey with the most beautiful sunset behind it, because the one thing I miss about El Paso, not almost as much as the Mexican food, is the absolute beautiful sunsets. So if you're familiar with Mount Cristo Rey, that's a gorgeous picture I took years ago. But two types of guardianships. Again, guardian of the person and guardian of the estate. Guardian of the person is the person appointed for the caregiving, well-being, physical well-being, etc. Guardian of the estate is involved with the assets. As you can probably guess, it's a lot harder in terms of complicated things you have to keep up with. It's a lot harder to be guardian of the estate. So if there are cases where we can avoid appointing somebody guardian of the estate, we do. We do everything in our power to try to avoid guardian of the estate, because that is a very expensive process. That person has to be very well versed in accounting and finances. They are responsible for the person's money just like a bank is. They have to invest the money wisely. They have to track it. They have to know every penny that comes in and every penny that goes out. And on a yearly basis, that accounting has to be provided to the court. Now, in a lot of situations I've been involved in, that person, even if they're not well versed to be able to do it themselves, because a lot of us aren't. I hate accounting. I hate everything to do with that. I have to hire a CPA. I hire a bookkeeper for my business because I don't like dealing with that stuff. Same thing in a guardianship. If you're appointed guardian of the estate, you might be the one responsible for the money, but you might have to hire professional services to make sure everything is properly accounted for and everything gets submitted to the court properly. If you don't do your job properly and you don't submit it properly, or you don't submit it on time, the court can take away that guardianship. And so the court has oversight over guardianships for years and years and years. That's one of the things that makes this process so darn expensive. The guardian of the person has an easier job in reporting, because all they have to do is every year they provide a report of well-being. How is this person doing? How's their health? How's that kind of stuff? That's not nearly as difficult. Most of my clients can do that on their own. But again, the same thing, that has to be provided yearly to the court, or if not, you'll lose your guardianship. Yesterday, when I did my case in Cleburne, it was a guardian of the person only, because we had an 18-year-old boy who was autistic. He is being cared for by great aunt and uncle. The only money he gets is Social Security. So he does get some Social Security disability, but because they can be his designated payees for that, we didn't have to do a guardian of the estate. We only did a guardian of the person for this family. So that's why it's so important you talk to a professional to be able to sort all that out and don't end up doing something you don't have to do. Next slide. Types of guardianship proceedings. The first one is an emergency guardianship. This one, we also called it earlier a temporary guardian. An emergency guardianship or a temporary guardianship is when there's a person's health, safety, property is in immediate danger. The court can appoint somebody on the basis who can protect that individual and protect their property. Now, it's an emergency guardianship because it doesn't require nearly the standard of proof that a permanent guardianship requires. In an emergency guardianship, as long as I provide enough information for the court to believe that this person needs help, that they can't care for themselves, and that their property or their person is in danger, that's enough. It's almost like a police officer having to have probable cause to arrest somebody. The police officer doesn't have to have all the proof in the world to convict the person. That's not their job. Their job is to have enough evidence to say this person did something wrong. Same thing with an emergency guardianship. We only need enough evidence to show the court something needs to be taken care of. Why? Because an emergency guardianship can always be undone. It can be undone really easily if there's a problem. So a permanent guardianship is very, very difficult to undo. So until we get a permanent guardian in place, a court will appoint a temporary guardian to safeguard the person and his property, his or her property, until we provide the court with proof that they can substantiate granting a permanent guardianship. Next slide. As I said earlier, temporary guardianship and emergency guardianship, although they are technically two different terms, they are two different categories of guardianship under the estates code. In the years that I've done this, I've never done a temporary guardianship that wasn't an emergency. So I'm not saying it can't happen, but it's very unlikely. So again, it's the guardianship is granted with far less evidence. The powers are typically limited. They're very limited to the danger that's involved, limited to the necessary to protect whatever the danger is. They're often transitioned over to a permanent guardianship, even if it's not the same person. So sometimes we'll get a temporary guardian appointed, and then we'll transition it to a permanent guardianship with a different person. Sometimes that happens, not a whole lot, but sometimes. And again, its whole purpose is to protect somebody in immediate danger. Next slide. Permanent guardianship. This is what I would call the 10 commandments of guardianship. This one's chiseled in stone. Once the court appoints a permanent guardianship, it's extremely difficult to change, modify, get rid of. It remains in effect until the court issues an order terminating it. A permanent guardianship can be transferred, but that can be problematic because guardianship is although guardianship is technically by state, if you become a guardian of a person in Texas, you are a legal guardian in the entire state. So no matter where you take that person or have that person you're caring for, you are their guardian. But every county requires you to have it registered in their county. So if you move from one county to another county, you have to transfer that guardianship. Now that process should be extremely easy unless you're dealing with difficult counties. And I'm not going to badmouth a county right off, but there is a county I live near that has a football team associated to it that is extremely difficult to deal with. The counties around it, not so difficult. I live in Collin County, and Collin County is fantastic to deal with. But I have a case right now where a person was a guardian in Hunt County, They had been granted full permanent guardianship abilities and everything, and we had to transfer it to this other county, Dallas County. And I am having major problems with the Dallas courts getting it transitioned because the Dallas court has the opinion that they want to investigate the entire thing because they're not sure Hunt County did it right. Well, courts aren't supposed to question each other like that unless there's something substantive that shows that a court did something wrong, which this is not the case here. But it makes it very difficult when you transfer sometimes. Now, what is difficult always is when you transition a guardianship from one state to another. So I've done that numerous times where a person established guardianship in Michigan, they moved from Michigan to Texas. We have to file everything here in Texas to transition it. Now, again, it's not difficult if you're in a good court. If I'm in a good court, for instance, Collin County will take all the paperwork that came from Michigan. They'll review everything. They'll make sure everything looks okay. And then they will grant the guardianship here. And typically it's not an outrageously expensive process and it's not outrageously difficult, but it depends on the judge. The one bad thing I always say that we have in Texas is we have elected judges. And sometimes those judges are not elected because they're the best person for the job. And we have good judges and we have bad judges. Yesterday, I was thrilled to be down in Cleburne and be before a judge that was phenomenal. He was outstanding. The way he handled himself, the way he handled the court, the way he handled my clients and myself, it made it so that it was seamless. We were in and out of that hearing in less than 20 minutes, and everything went exactly the way it should have gone. Unfortunately, sometimes you don't get that. So a permanent guardianship remains in effect until the court says otherwise. Next slide. Although the permanent guardianship doesn't expire, it can be taken away. Again, I told you earlier that if you don't file these reports that the court requires, the guardianship can be terminated or suspended. So if a guardian fails to file an annual report with the court or becomes disqualified for serving, why would a person be disqualified for serving? We haven't really gone into that yet, but in order to be a guardian in Texas, you have to be an upstanding person. You cannot be convicted of a felony. They will not let a person convicted of a felony become a guardian. If you have filed for bankruptcy, they are hesitant to let you be guardian of the estate unless it's been a lot of years and then things have, depending on, they take that one into consideration. So there's a lot of things that will disqualify a person from being a guardian. The one I've dealt with more than anything else, again, is criminal issues. If a person is a guardian and they get arrested and convicted, then the court could take them away and appoint another guardian. The court issued, what is that other? I want to make sure that I'm not missing anything here. Court issues letters of guardianship. So there are letters of guardianship for guardian of the person and guardian of the estate. These letters are these official seals from the court so that a guardian can show it to somebody to prove they're the person appointed. Yesterday in my hearing, we spent more time after the hearing in the clerk's office waiting for the clerk to print out 10 letters of guardianship for my client so that my client could give them to the ward's school, their doctors, all that kind of stuff. So those are the official things that show people and tell you that you're the guardian. Now, as the bottom of this slide says, the bottom right corner, they automatically expire 1 year and 4 months from the date of issuance. So every year, not only do you have to submit an annual report, you have to get new letters of guardianship. So this is where sometimes people will mess up and forget, and the guardianship gets threatened to be terminated. Typically, the court will give you a warning before they actually do it, and they'll say, hey, you didn't submit your report. If you don't submit it in the next 30 days, we're going to terminate the guardianship, and it gives people chances to do that. But so guardianship is a very responsible position, and people have to keep up with it on a yearly basis. Next slide. So let's look at some of the Texas laws relating to guardianship. Again, the Texas Estates Code is the biggest one. That's the one that goes over everything. In order to be qualified as a guardian, you have to do certain things. When these aren't the qualifications, the first thing I'm going to cover is not the qualifications to even apply to be a guardian. This is once you're appointed guardian, you have to do these certain things. You have to file an oath. You have to sign a sworn document swearing that you're going to do your job. You have to give a bond. The court will set a bond. The bond is typically very high if you are guardian of the estate and are managing a lot of money. A bond is a security. It's nothing more than an insurance policy saying if you don't do your job, the ward is taken care of. The ward's not going to lose money if their guardian steals it. So a bond is a protection. Yesterday, when my clients got appointed just guardian of the person, the court required a $100 bond per person. Now, sometimes I look at that, I'm like, what good is a $100 bond? I don't know what that secures, but the court says $100 per person. We went and paid that at the clerk's office. We filed the bond and we got it all in place. I've had many cases where we had to go and find an insurance company to issue a bond because the estate was worth $1 million. And if the state is worth $1 million, the court's going to require $1 million bond. There's not too many people that can put that money up. So they have to go find an insurance company that will insure that amount and issue the bond to the court. The judge has to approve the bond, and they have to take the outline training to become a certification, as I mentioned earlier. The training is required before the court will even hear the case. So we have to provide the court with the certification that these people have gone through training before they'll even have the hearing to consider appointing them as guardian. Next slide. People statutorily ineligible to be appointed guardian is again dictated by Estates Code 1104, 351 through 359. Next slide. A minor. Well, that one makes sense. Since a minor is considered an incapacitated person, we can't appoint an incapacitated person to take care of an incapacitated person. So minors are automatically disqualified. I love the rest of this definition because it leaves it up to so much discretion, and really the judge has a lot of discretion to decide what is and isn't fall into these categories. But number two, people whose conduct is notoriously inappropriate. Now, I think we can all think of some conduct that automatically falls into that category, but what about conduct that doesn't automatically fall into that category? Is a person that was arrested 10 years ago for DWI, is that enough to consider that person conduct of notorious inappropriateness? Some might say yes, some might say no. That's where the gray area really comes into play. And that's why when my clients hire me to do a guardianship, I ask them 1,001 questions, because I need to find out as much about them as possible so that it doesn't come up in court and I get surprised because they were arrested for shoplifting, and now all of a sudden that's come up and the court is considering that inappropriate conduct and considering disqualifying them. So it's really an area that is very, we really have to delve into that. Number three, an incapacitated person. Again, of course, that one's obvious. Number four, a person who is a party or whose parent is a party to a lawsuit concerning or affecting the welfare of the proposed ward. So I'm not going to be appointed their guardian if I'm suing them. So the court wants to look at, is there any issues, financial issues, or any lawsuit issues between the person applying to be guardian and the ward? But again, also on number five, it's not just a lawsuit, it's indebtedness. So the court might ask the guardian, does the ward owe you, or do you owe the ward any money? Have you guys ever borrowed money and not paid it back, etc.? That comes into play a lot on guardian of the estate issues. Next slide. So a person asserting opposing claim against the ward similar to a lawsuit, but not as official. So a lot of times the court will delve into this, making sure that there's no issues between the person and the guardian and the ward. A person who, because of inexperience, lack of education, or other good reason, is incapable of properly or prudently managing, boy, that's as broad as they come. So that one is to me, a blanket disqualification, that if a court for some reason doesn't want this person, they can always claim that one. They can always say, well, you don't fall under the experience, education, and good reason. You're not really capable of taking care of this person. I personally have never seen somebody disqualified under number 7, but it can happen. A person, institution, or corporation found unsuitable, again, the same thing, very, very broad. A person disqualified in declaration made by the ward prior to incapacity. So where that comes into play, number 9, every time I do estate planning for people, I do a document called designation of representative, or designation of guardian in case of future incapacitation. And so while a person is well, they decide who they would want their guardian to be if they ever become totally incapacitated. So I say, I want these people to be my guardian. I name a first, second, third. If I become incapacitated in the future, these are the 3 people I would like to be my guardian. I can also, within that document, say, these are the people I don't want my guardian to be. So if I have troublemakers in the family, if I have people I just don't want to be involved, I can disqualify them in that document. Now, the court will take that document into consideration at the time of guardianship. And so if one of the people I have said I don't want my guardian to be is on that document and it's presented to the court will not appoint them as guardian if I said, while I was well, I didn't want them to be my guardian. So that is a big one. I've had that one come up more than one time. So I always tell my clients when they do their estate planning, don't just tell me who you want your guardian to be. Tell me who you don't want your guardian to be if there are people in the family like that. I'll be honest, when I did mine, I disqualified my mom. My mom is now 91 years old, but the last time I updated my document, she was in her 80s, late 80s. And I disqualified her because I told her this. I said, Mom, you are aging. I'm caring for you now. You don't need to feel responsible to care for me if I became incapacitated. And like a typical mom, she says, what makes you think I'd want to be your guardian? And I told her, yeah, Mom, I get it. You're funny, but I'm your baby, whether I'm 5 or I'm 50. You're going to feel as a mom responsible. So I disqualified her on my form. So it's not just people that are problems, but it is also people you just don't want to burden. Next slide. Pros and cons of guardianship. What are the good and bad of this? Number 1, guardianships protect those who are vulnerable. Number 2, but it is the most restrictive action that can be taken. So it is a last resort. The courts will always look at it as an absolute last resort. Can anything else be done prior to guardianship? And if the court determines no, then they'll move forward with the guardianship because it is so restrictive. It helps the ward with both their personal and their financial affairs. But the ward loses numerous rights. Number 1, they can't drive or vote anymore, along with a bunch of other stuff. It gives the ward an advocate, somebody to fight for them, somebody to stand up for them and help them. But it can take family out of the process, especially if families are fighting and don't get along. It does provide protection through the court supervision. There is court oversight over this. But again, it can limit family members' even access to the ward. I've been involved in guardianships where the court has issued orders not allowing certain family members to come see this person because they're so problematic and they're not healthy for this person, that they basically issued an order saying you are to stay away. And if you don't stay away, you're going to be arrested. One of the pros is it requires a licensed medical professional to provide a certified medical examination report. Now, I talked about it earlier that the requirements for a temporary guardian are less than a permanent guardian. A temporary guardianship does not require this CME form. So I can go into court and provide evidence to show this person needs help and that they're in danger. And that's all I need. Then when I move it to a permanent guardianship, though, the court's going to require this CME form. The CME has to be filled out by a medical professional. The medical professional has to say, in their professional medical opinion, the ward cannot care for themselves. The ward cannot make decisions for themselves. The ward cannot manage their own money. And so we have trouble with this sometimes. Sometimes doctors don't want to fill it out. Sometimes the ward doesn't want to cooperate to see the doctor to fill it out. I have one right now where we're getting an order from the court ordering the ward to be subjected to this medical examination because she's refusing to do it. And so that's, again, every time those kind of things happen, it's more money, it's more legal fees, it's more expenses to the guardianship. The con, again, is it's very humiliating. It's a very humiliating process, and it's extremely time consuming. There is legal recourse if anybody does anything wrong. So again, the court oversight allows for legal recourse if people do bad things, but the court also has continued involvement. We have to continually report to the court annually. We have to do these reports. We have to submit these things. And every time we do that, there's more finances, there's more fees, there's more legal and accounting fees, etc. It gives the ward a strong support system, but at the same time, if the ward fights the process and they don't cooperate, which we often see with Alzheimer's, and especially Alzheimer's that has gotten to the point of paranoia, if they don't cooperate, it makes it a very difficult process. It can give the family members peace of mind, because I've had so many times that people are like, they're at their wits' end trying to care for somebody. Now you can see there's both a pro and a con of the letters of guardianship. I think it's a pro because you have to have that proof. You have to get the authority of the court, but it's very tedious because you have to keep doing it every year. You have to remember to go back. You have to remember to renew it. And if you don't, it can expire. It does make it easier to get things done, but terminating and modifying it is difficult. Transitioning it or transferring it is difficult. And again, as I put there, I got nothing else on the pros, because to me, the cons outweigh the pros, but it's a necessary process that we can't avoid when somebody needs to be cared for. Why is it so expensive? Why are guardianships so darn expensive? I always tell my clients, typically you're going to look at a $10,000 to $15,000 process. Now, that doesn't mean guardianship of a minor like yesterday is outrageous. So again, I look at guardianships as, we call them aging out guardianships. Aging out guardianships is when a special needs child becomes an 18-year-old adult and needs guardianship. Those guardianships aren't nearly as expensive as the guardians of elderly, dementia, Alzheimer's, somebody with traumatic brain injury, somebody that was in a horrible car accident. You know, adults that become incapacitated, it becomes very expensive because there's legal fees, there's court costs, there are accounting fees, there are investigation fees. The court will appoint an ad litem attorney. Go ahead and keep moving forward, Marty. The court will appoint an ad litem attorney. The court will appoint an investigator. We have to pay those fees. Sometimes the court will even appoint a guardian ad litem. The attorney ad litem is an advocate for the ward. They basically are the attorney for the ward. The guardian ad litem is a temporary person to care for the ward during the process to make sure they're taken care of throughout the process. Next slide. There are medical assessment fees. As I said earlier, you have to go to a doctor and get a CME. The doctors usually don't do that for free. If a doctor will do that as part of being their patient, that's a lot cheaper than what I'm going through right now and having to get a court order ordering this person to see a neurologist or a psychiatrist. If I have to go to a neurologist or a psychiatrist, I always tell my clients, you're probably looking at a minimum of $1,000. They're going to cost, $1,000 to do that medical assessment fee. There could be appraisement fees if there's property involved that we need to find out how much it is. These are typically with the estates that have houses, they have real estate, they have other valuables that we need to account for. There's the cost of notifying family members. There's, you have to notify everybody that could possibly be involved in this. When yesterday I had to let the court know, okay, this ward, because great aunt and great uncle are the ones becoming the guardian, the ward wants to know, the court wants to know, does the ward have a parent? Where's mom? Where's dad? Why aren't they involved in the process? Does the court have siblings? And if so, are any of those siblings adults? Does the court have an aunt and uncle? Do they have grandparents? And so we have to let the court know of all these people, and we have to notify those people and give them an opportunity to be involved in the process if they want to. And then there's administrative fees, bond premiums, ongoing court costs, accounting fees, additional legal fees. It just goes on and on and on. So alternatives to guardianship, these are the things we look at before we ever move forward with a guardianship. Is there alternatives that we can use to make sure we can care for somebody before we have to step into court? Number one, estate planning. I think it's funny that every topic I talk about, everything I do in my arena, I am an estate planning and elder law attorney. Elder law includes probate when people pass away. Do they pass away with a will, without a will? Did they have a trust or did they not have a trust? Who's the family involved? And guardianship. All of it goes back to estate planning. Did these people have documents in place before they needed it that can take care of them when they need it? I always tell people, will ask me, well, when should I do my estate plan? And the answer is now. You do the estate plan when you don't need it. If you wait until the time you need it, it's going to be too late. I get those calls all the time, and I've said this on prior webinars. I get a call saying mom is I've had to put mom in a nursing home. She's now moving over to memory care because she's got Alzheimer's, and I need to bring mom in so I can do a power of attorney for mom so I can take care of mom's finances. And I tell people, well, it's too late. If mom is already going to memory care, the likelihood is she can't sign a document she doesn't know what she's signing. So estate planning, so important. Making sure you have things in place prior to the time you need it. Now, I don't want to really go off on a get in a rabbit hole here, but a trust is by far the best thing anybody can ever have, because a trust can avoid guardianship if it's a properly drafted trust. I had a case in El Paso where daughter had taken care of mom for years. Daughter had what she thought was all of her estate planning documents. Mom had a will, mom had power of attorney, mom had medical power of attorney, mom had medical directive, HIPAA form, the whole bit. Everything was fine until mom's Alzheimer's got to paranoia. Mom all of a sudden started believing that the daughter was stealing all her money, that daughter wanted her dead and didn't want her in her life anymore, that daughter didn't love her anymore. Even though none of that was true, mom called her doctors and said, don't talk to my daughter anymore. She called the bank and said, don't talk to my daughter anymore. Even though the bank and the daughter and the doctors knew mom wasn't right, they had to honor mom's wishes. And overnight, those documents that she had used became void, because those documents are, I giveth, I can taketh away. I give you permission to take care of me. I can take that permission away, even if I'm not right up here. So overnight, daughter had no authority to take care of her mom. She panicked. All we could do at that point is a guardianship. I filed for guardianship. Months go by. We finally get her appointed guardian. She, thousands of dollars later, she finally has the authority to take care of mom the same way she did with the other documents before mom stopped cooperating. If mom would have had a trust that was properly drafted and daughter would have been trustee of that trust, none of that would have happened, because the trust would allow somebody to care for you whether you cooperate or not. So I always say, in my trust, I tell people, I'm giving you permission to care for me even if I stop cooperating. Now, they have to prove that I'm incapacitated. We want safeguards in there, but that can save thousands and thousands of dollars. So if anybody wants more information about that, I'll be more than happy to share that with you later, or you should consult with an attorney in your area, a professional in estate planning and elder law, find out more about that. You also can get appointed representative payees. I talked about that a little bit earlier with Social Security, SSI, SSDI, the VA does that, etc. You can have a caregiver. Sometimes when a person you can have somebody come into the house or whatever and care for them, and you can get away with not doing a guardianship for some amount of time. Again, a lot of times these alternatives work only when the ward or the proposed ward, the person that needs to be cared for, only when they cooperate. Next slide. There are money management programs in Texas. If anybody wants to know more about that, I highly recommend you Google that term, money management programs in Texas. Now, joint bank accounts is kind of a yes, it's good, no, it's not good. It all depends. A joint bank account is good if the person doesn't have a lot of money. If the person does have a lot of money, I don't recommend that to my clients because there's liability issues. If I went through bankruptcy and I'm a joint on my mom's account, they can take her money away from her. I don't want that. You know, there's certain drawbacks to a joint bank account. So we look at those on a case-by-case basis. I am a joint on my mom's account because I'm her designated payee for her Social Security and her her military benefits. She's a military spouse. That money comes into that account that I'm a joint on, and I can pay her nursing home expenses. She's also on Medicaid, and I'm a representative on all that. Now, that makes it easy because my mom doesn't have anything. Money comes in, money goes out every single month. That works fine. But on other cases, when there is more money, I don't advise that. There's community services. There's always kind of community services involved. There's Meals on Wheels. There's other things out there that you can do and provide services to the person that needs help if need be. And there are supported decision-making agreements. A supported decision-making agreement is kind of a contract between the person caring for them and the person that needs care, saying, I'm allowing you to care for me. Again, when you look at all of these, it requires cooperation of the person that needs help. Again, you want to look at eligibility. Do they qualify for Medicaid or other benefits that are out there that can help that person? I am not my mom's guardian. I've never had to become my mom's guardian because I have her power of attorney and all of her other documents. I'm her joint on her accounts, and we've gotten her eligible for these Medicaid programs. So I've been blessed, even though my mom will turn 92 years old in January. She still is of a very sound mind. Her body is quitting, but her mind isn't. And so she's been extremely cooperative with me through the entire process. And that's made it so much easier on me being able to care for her without having to go get a guardianship. But again, most of the time, guardianships have to be when the person is not at the point of being able to completely cooperate. There is a management of community property. That's with a marriage. So a husband and wife, the healthy spouse has the ability to manage the community property on behalf of the unhealthy spouse. Those are kind of unique to married couples, and you need to talk to an attorney to really understand that more. Determine if the incapacitated person is eligible for Medicaid and find services again in your area. I'm sure Marty has a lot of resources of services that he can provide people that are aging and need these services. And again, adult protective services has to be called in when there are dangers involved and there's issues involved with the person not being properly cared for, being taken advantage of, or exploited. So why you want to avoid guardianship? It's expensive, it's humiliating, it's time consuming, and it's a public process. It's in the courts. Anytime you're in the courts, you're in the public eye. It requires attorneys. You cannot do it on your own. And God help you if you even would want to. You don't want to do it on your own. It's very difficult. So it requires attorneys, it requires courts, it sometimes requires government agencies, etc., like Adult Protective Services. And again, it's the most restrictive action taken to take care of a vulnerable person. The person loses their rights, which we don't like. Sometimes when they're incapacitated, I've actually had cases where the court postponed a guardianship by telling the person, "Hey, if I make your daughter the guardian, you're going to lose your right to vote. You don't want to lose your right to vote, do you?" And the person is well enough to say, "No, I don't want that." And so we had a case, that case I had in El Paso, where the lady had taken care of her mom for years. We were able to postpone the guardianship for a few months because the court talked to the ward and said, either you allow your daughter to take care of you with your documents, or I'm going to have to do a guardianship and take all your rights away. And the lady said, "I don't want you to take my rights away." And so the judge says, "Well, cooperate then." And so she did. She cooperated for a few months, but she stopped cooperating again. We had to go back into court and eventually get the guardianship. Again, it can take family members out of the picture, and it can really affect a family structure and family dynamics in very bad ways. For about 6 years after I switched over, I was a trial attorney for the first 10 years of my life as an attorney. And then I switched over to estate planning and elder law. My first 6 years of doing that, I did almost nothing but contested probates and contested guardianships. Families fighting over this. And it is horrible. It's nasty. And I always tell people, when a family fights in probate or a family fights in guardianship, the only person that wins is me, the attorneys. The attorneys win the more you fight, because the more you fight, the higher the legal fees, and it's a horrible thing. So I do little to no contested issues now, but they're out there, unfortunately. This last slide has some resources. You're going to get a copy of this, but these are some websites I highly recommend you look at that will give you some excellent resources and information about guardianship in Texas. If you are not from Texas, if you're watching this from another state, your state has the same thing. So just Google your state's agencies and you'll be able to find what you need. Now, I think I've left enough time for some question and answer. But thank you, guys, and I'm going to turn it over to Sheila.
Good, because there's 20.
Oh, my gosh.
Okay. First one, anonymous. What is the typical cost of guardianship, which you did answer, but are there any community resources that assist with this cost for low income? Marty, you attempted to answer that with telling them about the legal aid. However, then someone else answered that it's hard to get them to do this because of, let me read exactly what she said.
She was concerned because they don't consider the income of the ward, they consider the income of the person applying, and the fact that I know legal aid's threshold for services is very low. You have to be extremely low income to qualify. The other thing that I would suggest is you check with your local bar association, because sometimes they can give you and sometimes they even have a rotating attorneys program set up where attorneys take pro bono cases on kind of a rotating basis to spread it around. But those are the only two I know in our area, in our service area. But there's just for legal aid of Northwest Texas, there should be a nonprofit legal aid for any county you're in. You just need to know legal aid of Northwest Texas is what services our area.
Okay, second one. Bradley wants to know, Fred, what state office should people contact for certification as a guardian? That's a good one.
Well, I think it's under Texas Health and Human Services. I think they're the ones that do the certification.
Marty, do you know that?
I don't. We've done some other trainings, but I think you can also talk to the probate court, and they'll tell you who provides those services in your area.
Okay. Crystal wants to know, what is the turnaround time, Fred, for a temporary or emergency guardianship? Typical.
Very quickly. I mean, in the scheme of things, I could typically do a temporary guardianship in a couple weeks, and sometimes even faster than that, depending on who the court is, what county you're in, and unfortunately, the county dictates a lot because the judges of every county are different, and I alluded to it earlier. But Dallas County is difficult. They're just a very difficult county to deal with. And I can't get things done fast in Dallas County like I can in Tarrant and Collin and Denton even. And some of the outlying counties, like, well, yesterday I was in Johnson County down in Cleburne, they're better. So the courts, even Dallas County, though, if I can put it forth and I can get their attention and I can make them realize that it has to be done now or somebody's going to be taken advantage of or harmed, then they'll typically get us a hearing in like 10 days.
Good. Okay. The next one is from Julie. Can you name a successor guardian in your will?
Okay. In your will, you can't technically name your guardians. I mean, okay. So let me back up. Technically, you can name your guardians, but it's the dumbest thing you could ever do because your will is a death document. Your will means nothing until the day you die. And so why would you name your guardians in your will? Because guardians are for life. And so I always tell people that. Same with, you can name guardians for your minor children. So if I have minor children and I say, if I die, I want Aunt Lulu to be the guardian, I can name that in my will, but it's not smart to do that because a will doesn't even go into effect until I die. And I always tell people a will should be called a wish because all it is your wishes on paper until a judge views it, accepts it, acknowledges it, and puts it into effect. And a will in probate like that can take 30, 45 days. So you can name your guardian in a form that's called designation of guardian in case of future incapacitation. That's a form we do for life. And that says, if I become incapacitated, this is who I want my guardian to be. And you name who your primary guardian is, first alternate and second alternate. Now, you can't name a successor guardian. The courts, again, will not allow you to have somebody appointed primary guardian and successor guardian. They won't do that. They'll only appoint one person or a couple if it's a married couple. And that person is in place until something happens. And if you need a successor later, they will look at your sheet that you've named and they'll look at, okay, I've named this person second, this person third, and they can step in. But again, it all requires going through the courts.
Okay. Next, Jennifer asked, how do we file a foreign court order in Texas? And she says, a California guardianship order.
Okay. So if you have and I don't know why you would need to file a California order in Texas unless the person moved to Texas. You don't have to just file it. So I'm assuming by the question that the person got guardianship in California. Now they're living in Texas. That foreign order from California has to be filed in the county that the person resides in, and it's a transfer of guardianship. You're doing an application to transfer the guardianship from California to Texas, and they'll go through that whole process. You cannot do it on your own. You have to hire an attorney to do that. The law requires it.
And you mean the county the person lives in now?
The county where the ward lives in now, yes.
Right. Okay, just to be clarified. Okay, Carmen asked, if an individual has designated a medical power of attorney, is it possible for them to also have a guardian?
Yes, that medical power of attorney can apply for guardianship, but I always recommend that people do the separate form that says who you want your guardian to be, because a medical power of attorney, all you're doing is you're designating somebody to make medical treatment decisions for you if you can't make them yourself. So in essence, a medical power of attorney says, if the doctors can't talk to me, this is who I want them to talk to. But it doesn't have anything to do really with guardianship. It's a whole separate issue.
Okay. The next one is from Yolanda. Gotta find it. Hold on. Back to this. Well, I thought.
And while she was looking for that,
here it is. Oh, okay. Okay, go ahead.
Those of you all that were wondering, if you were wondering if this picture came from El Paso, it didn't. This picture did not come from El Paso.
I don't think anybody wondered that, Fred, but thank you for that clarification.
Just in case.
Okay, Yolanda wants to know, this is a good one too. Are spouses automatic guardians?
No.
Well, that was fast. Okay. Okay, this one came from an iPad. Do you know if a person guardianship for my son affects his Medicaid services?
No, it shouldn't. A guardianship can support Medicaid services, so it basically allows somebody to step in and deal with Medicaid, but it should not affect the Medicaid services at all.
Okay. The next one is from Stephanie. If the adult ward is getting government income, how do we assign it to the guardian without spending court case fees? I am having issues finding an attorney in DFW.
Well, if there's a guardian, again, the people use the term guardian way too loosely, because sometimes a person will tell me, well, they're the guardian, but they're not. They're the caretaker. They're the spouse, but they're not the legal, court-ordered guardian. And so if they are a court-ordered guardian, that person with their letters of guardianship should be able to reach out to the governmental entity, Social Security, whoever, and become the designated payee for the ward. So you shouldn't need an attorney to do that. You should be able to do that on your own. If that doesn't answer your question and there's more to this question than I'm looking at, reach out to Sheila. I'll be more than happy to talk to you outside of this thing and see where I can guide you in the right direction.
Okay, the next one is from, okay. Are there resources for low-income families who need to seek guardianship for adult children with disabilities? So again, special needs, yeah.
Again, what Marty said earlier, there's the legal aid, but I find it very difficult. I don't think there's nearly enough resources out there for people like that. There are, and I find even with legal aid, those attorneys aren't versed in this. They're not experts in this area. They don't know how to do it, and sometimes they'll shy away from it because it is a complicated area. And so I find with legal aid attorneys, a lot of them are doing so much family law that they don't know these other areas of law well, and just don't like doing it. They don't feel comfortable doing it.
And I think part of it is, in my experience, most of them have as you mentioned earlier, they're general physicians. They're your primary care physician. They're not the surgeon. They're not the professional. And I think legal aid has a lot of their primary care attorneys, but not all of them. I don't know that they have specialists. And so you might again call your local oh God, legal aid, not legal aid, attorney association. What is it? To help
State bar.
That's right.
State bar.
So just so everybody's aware, there is the State Bar of Texas or the State Bar of the state you're in, but typically there's also bar associations where you live. Yes. So like Dallas has a bar association, Arlington has a bar association, Fort Worth has a bar association, Collin County has a bar. So you might also look at your local bar association to see if there's any pro bono attorneys out there that would help.
And there's some that are even under different categories. I don't know if there's one that is specifically Hispanic bar associations, but there are some that are just specifically targeted too. So you really want to check out what bar associations are available in the area you're trying to get services.
Exactly.
Okay, the next one is from Anonymous. it sounds like most people who need guardianship have little money. How would a guardianship business actually make money? That's good. That's a good question.
Well, that is a good question. A lot of times the guardianship businesses I've dealt with do either one or two ways. It's almost like a nursing homes extended stay. They're either private pay or they're government pay. And so a lot of my guardianship businesses I've dealt with were either private pay, and they just had to get the money from people. So the people that hired them had to pay them, or they were associated with the government. For instance, in El Paso, Project LULAC not only was a nonprofit and they had nonprofit money to help, but they were also tied into the county government. So if I had an indigent person and the county got a hold of it, or let's say a police were involved or somebody, they would go through the county and the county would get Project LULAC involved and the county paid some of their fees. So it's either you're tied to a governmental entity and you get paid that way, or you're a private pay.
Fred, would you say it's a misnomer to assume that people that need guardian are low income? I think there's people all. It's just we see the people low income because they're trying to figure out how to get it done when they don't have any money. But I think there's people that need guardian and have no family,
Yes.
That have all sorts of resources.
You're exactly right. I don't find that the money is as big of an issue as not having the proper person to do it or whatever.
And could we put it? I know lots of people are here from here. I'm sorry, on here from El Paso, or some are. But could we put them in touch with, in order to help get that done, the organizations you're talking about in El Paso, and maybe they go talk to them directly and figure out how they're set up and how they're funded.
Sure. I mean, if anybody's curious about that, again, you're going to have Sheila's email when all this is said and done. Sheila gets questions after these things. And so I'll be more than happy to put you in contact to any resources that I have to help you do that, because it's desperate need all over the state and all over the country. There's a desperate need for these services.
Okay, next one. Harriet wants to know, where do you go to get this training and how much does it cost?
And again, I think it's all goes through the Texas Health and Human Services Department. I think they're the basis for all the training that goes on with this.
We've done training through North Texas Health Services of North Texas. I believe we used to partner with them to put on these trainings, and some of the people in the trainings were having to were court appointed to actually take the training, and so we used to put those on. It's been a few years, but we put some of those trainings on.
Well, maybe you should do another one.
I know. That's a good idea.
Okay, next one is from Cynthia. She says, I understood that once my son reaches 18, his income will no longer be determined by my income. It will be solely on his own self. Is this not true?
I think that's correct. I don't know what the question is in regards to guardianship, but yes, typically once a person turns 18, they're an adult, and I mean, it depends on what you're looking at. So for instance, if my daughter goes to college, they're still going to look at my income for her financial aid and stuff. So it depends on what you're dealing with. But if you're talking in a guardianship situation where what I would call an aging out guardianship, where somebody is special needs and they become 18, then yes, that is correct. The minute they're 18, the courts or the people don't look at the parents' income. It's the ward's income as far as qualifications.
Okay, here's another simple. Well, my son is 36 and developmentally delayed and is receiving Medicaid. We moved to Texas 4 years ago and still not sure if we need to have a guardianship. What type of attorney or organization can we seek to confirm if guardianship is needed?
Anybody that specializes in elder law is an attorney that works in this area. Now, I always tell people, if you're not having problems and you're not getting pushback from doctors and you're not getting pushback from, whether they have work and they're in work, if you're not having problems taking care of your special needs adult, then you don't need guardianship. typically. My nephew is autistic. My nephew is 46 years old, I think. I think he's 46. We have never done guardianship for him because we've never had to. My sister has been able to care for him his whole life. He drives. He actually got his driver's license. He lives with her still, so she's caring for him, and he has a job. And so the doctors have never given my sister pushback. Nobody's given my sister problems. So we've never sought guardianship for him. And so I always tell people, you'll know when you need guardianship, typically, because you're going to have problems, and all of a sudden we're going to say, "Oh crud, now what?" My case yesterday, great aunt, great uncle taking care of this boy. He had to go to the emergency room 2 weeks ago, and they gave her nothing but problems at the emergency room because she wasn't his guardian yet, and she couldn't make decisions for him. And they're telling her, well, he needs to sign these papers. And she's telling them he doesn't know what he's signing. And it was a problem. It was a major problem. Those people need guardianship. Now, if you're taking care of your own son and you're not getting pushback, then I tell people avoid guardianship as long as you can.
Okay. Cynthia again. She wants to know, does the aging out guardianship, which you're just speaking of, require a yearly renewal, just like the other one? Just making sure it does. Yes. Okay. Okay.
But again, typically on aging out guardianships, you're only doing guardian of the person. You know, sometimes I have to do guardianship of the estate, but not very often. So on an aging out guardianship, the yearly renewal is renewing their letters and filing a report of well-being. It's not a hard process.
Okay. The next one is from Sherry. Can the doctor providing the CME be required to testify before the court for any reason?
Yes, technically they can. I don't ever see that. I've never had a case where the court required us to subpoena the doctor into court to testify. They'll typically take that CME as a sworn statement.
Okay. Next one. We have a trust that was done in California 4 years ago. Do we need a Texas attorney to transfer or redo the trust?
Yes, ma'am. You always want to have your estate planning documents from the state you live in. Big problem with California trusts is California trusts don't have language in them that Texas requires, especially for homestead protections and homestead exemptions, and for community property protections that we have in Texas. So I always tell people, no matter where you're moving, if you're moving from Texas to another state, you need to talk to an attorney in the state you live in about the documents that are done in that state to make sure you're compliant with the state you live in.
Okay, Linda wants to know, please explain being a successor guardian, and can this be used to replace the guardian who dies?
Okay, the term successor guardian is kind of a misnomer because there's no official successor guardian. So it's not like the court recognizes somebody as a successor guardian. The family might recognize somebody as a successor guardian, saying, okay, if mom can't take care of son, then brother's going to step in. So the successor guardian is the person that would step in when the time is needed. Now, what was the second part of that question, Sheila?
Can it be used to replace someone who was the guardian who passed away?
Yes.
Okay. I mean, that you'd think that would be the whole reason for it.
Yeah, that's one of the main reasons, yes.
Coming from a non-attorney, you'd think that would be anyway. Okay, Monica wants to know, what if the doctor had stated in your case that, back from El Paso, what if the doctor had stated that the mother wasn't able to make decisions? Could that have eased the situation you have?
No, because the doctor did. So the doctor, we had all kinds of medical evidence showing that mom's Alzheimer's was bad and that mom wasn't thinking right. But the law says it doesn't matter. You can, again, those documents are I giveth, I can taketh away. I give people permission to take care of my finances. I give people permission to take care of my healthcare decisions. but I can take that decision away even if I'm not right up here. And so that's what happened is she verbally revoked all of her documents. And like I said earlier, the doctors knew. The doctors knew she wasn't thinking straight. The bank knew she wasn't thinking straight, but they had to honor her wishes until we went into court.
Christopher asked, in the case of the proposed ward refusing a CME, which is another case you're dealing with, if the court orders it and the ward still refuses, what happens or could happen at that point?
So the ward can't refuse it because somebody will physically take that person before the doctor. The doctor's going to do an examination. Now, they may not cooperate with the examination. That's up to them. But the doctor's going to still issue a report saying, I tried to do this, I tried to do this, I tried to do this. They refuse to cooperate. And so the doctor will still have enough information to be able to tell the court that the person is not acting properly.
Okay, Yolanda wants, this is a general question. Besides living will and testament, so your will and testament, power of attorney for health and financial, what other documents do I need to have for the spouse with dementia before it gets worse?
Okay, so she needs to come to one of our other CLEs
Yeah.
because we covered that in very much detail. And again, if you go to our website, we have a page on our website with all our prior webinars. So there are webinars on our website about this if you want to know more in detail, but I'm going to go through it very quickly. So everybody needs living documents and death documents. The living documents include a power of attorney, medical power of attorney, medical directive, or what's also called a directive to physicians or a living will, HIPAA form, declaration of guardian in case of future incapacitation, designation of representative to carry out my remains, and anatomical gift form if you choose to donate your organs for transplantation purposes. Then from there, we look at doing a will or we look at doing a trust. If you do a trust, you still have a will, but it's a special will called a pour over will that pours everything into your trust because you want your trust to control everything. So those are the documents I recommend everybody have.
And we have those on our YouTube channel too, all the recordings from the previous
ones Thank you, Marty.
You've done for us. So either way, yeah.
Yeah, go ahead. Sue Ann wants to know, where do you find this designation of guardian form? Is it necessary to have an attorney file it?
These forms aren't filed. So that's a misnomer that people think, well, I do a power of attorney, I do all these forms and they're filed. No, they're not. They're kept with the family. And I don't know, I never recommend people do online forms. So I always recommend if you want it done right, you do it with an attorney, because attorneys, that's what we do. That's why we do what we do. So I don't know where you could find that form other than seeing an attorney about it.
Well, and the other thing Fred usually brings up, which is an important point, is, you end up not knowing that the form you got online doesn't work until after it's too late, because you're just not going to you're going to find out when it's too late, and you can't, it's too late to do anything about it. So you want to make sure it's done right the first time. Sheila, will you go over the CEUs real quick?
Yes, because people are leaving. I need it.
Yes, go ahead.
Okay. Once again, Marty will send you a follow-up email tomorrow with the slides again, in case you didn't get the slides today. And it will also have the two form documents that I need returned back to me. The guardianship eval form, which, eval form you do for every CEU you go to, and then the sign-in sheet. And I need both of these before I can issue your certificate, but I will be more than happy to do so.
And then you make sure you send those to Sheila at her email address. And please do that. We're going to give you just a little over a week to do that, or a week from tomorrow. So we've got to cut that off. We just can't spend so much time chasing down one CEU here and one CEU there. It's very, very time consuming. The other thing is, please, there's a Google evaluation survey, as we always have. It should give you the chance to go there as you log out today, but you'll also receive a link to that in the follow-up email as well. So, I mean, you guys, I'm going to go to the next one real quick. I know we're over time. I should have done this earlier. Sorry. But next month we're going to talk about blended families, a Brady Bunch nightmare, and its effect on care, estates, guardianship, and something else that I can't see. Probate. I'm sorry. The pictures are hiding.
No, I can't see it either.
So you guys can. I don't know if there's any more questions. I just want to try to get that before we lost too many people.
This one is a good one. Let's do this one. Cynthia asked, in my mother's will, it does say in the event that I cannot make decisions, I guess she's talking about her mother, then I appoint so-and-so as guardian. So do I need to get lawyers for that and go through the courts, or is her will enough?
So that is a horrible, horrible statement in a will. Horrible. And I don't know where your mom had it done, or if she had somebody do it, or she did it online. But however that was done, it was done improperly, because that statement is a life statement. A will is a death document. So you can't have a life statement in a death document when a death document is even good until a court sees it after death. So that needs to be redone.
All right. One more, because this is you. I think I can see a lot of people wanting to know this. My son is 17 and is a senior in high school, but he will be 18 next year. He's autistic. Will I need to file for guardianship after he turns 18?
You should start the process for guardianship at 17 and a half. So I always tell people to contact me about 6 months or so before the child turns 18 so that we can start the process. That way we can get the guardianship in place right after they turn 18.
Anything else?
Well,
are you looking at something else, Sheila?
Yeah, but I don't.
You looked a little shell shocked.
Well, okay, I'm just going to read this. Donald says he disagrees with your advice, and you can understand which advice he's talking about when you hear the rest of this. If you know your special person is not competent, then get the guardianship in place before it becomes an emergency. Emergencies are always a bigger problems and much more expensive, and never done timely enough to resolve the emergency that led to the need for the matter.
I completely agree with you, Don. That is exactly right. And that's not what I was saying earlier. What I was saying earlier is if you've already been 36 years and haven't needed a guardianship, why jump through hoops right now? Because you may not need one. And so I always tell people that typically, it's always better to do things up front. So sure, if you have the money and you want to just be safe than sorry, then sure, jump on that guardianship. But it's not absolutely necessary when you have a situation like was described earlier. Yes, I advise that everybody that has a special needs child that is turning 18 do an aging out guardianship so that you're immediately the guardian the minute they turn 18, so you will never have problems. But not everybody does that. And again, my sister, I'm an attorney. I've been talking to my sister for years about it. She doesn't want to do a guardianship. And I've been saying, okay, we'll just wait until you're, and if there's a problem, we'll deal with it, because I'm an attorney and I can deal with it when it becomes a problem. But you're exactly right. It's always more expensive. It's always worse when there's an emergency and you can't take care of things. So yes, I completely agree with what Don just said.
Okay. Well, one more. The person that asked about the California to Texas trust, she has a special need, or he or she, I can't, anyway, has a special needs adult son. What type of attorney do they need to seek? Oh,
an elder law attorney is somebody that does estate planning and elder law.
But special needs as well.
Well, typically most estate planning and elder law deal with special needs. It depends on what she's going to need help with. Is she going to need help with the estate planning part of preparing for the special needs person in their inheritance and doing like a special needs trust? Or do we need to look at guardianship? So typically an estate planning elder law attorney will have at least enough knowledge to know what direction to go.
And okay, one more in that case. This person has a 17-year-old on the spectrum, but high functioning with an intellectual disability, operating on a 10-year-old fifth grade level. His ability to be influenced and manipulated is very high. Is there a way to protect him without guardianship?
No.
Okay.
Not once he turns 18, there's not.
Okay. Okay, I don't know that you're going to know this, but yes, well, okay, I already have full guardianship of my 7-year-old granddaughter with no medical disabilities.
Okay, let me stop you there. I started looking at that one, Sheila.
Okay.
So if you have guardianship of a 7-year-old with no disabilities in California, that's not a guardianship in Texas. That's a conservatorship.
Yes. Okay.
And that needs to be dealt with in family court, not in probate court. So if you're transferring that to Texas and you need to stay legal authority of a 7-year-old in Texas, you need to talk to a family law attorney. And I think she said she was in Bexar County down in San Antonio. So you need to find a family law attorney in Bexar County and speak to them about this.
Okay.
Are we done?
That's it.
That's
great.
Marty.
I don't know.
I'm tired. And people are already emailing me for stuff about what we're talking about. So thank you, Sheila, Fred. Thank you so very much.
Thank you, guys.
Thank you for your, not only that, but thank you for staying over time to answer the questions. We've been 15 minutes over time. So, but thank you all for joining us, and we all hope you have a wonderful day.
God bless you all. Take care. Bye, everybody.